So, it's the great case of New York Times versus Sullivan. Maybe the most important First Amendment decision of all time. Certainly the most educational in what it tells us about freedom of speech in the press. And I'd like to discuss the case in 4 steps. First, look at it as a common law case and see how L.B. Sullivan's case stacked up in meeting the common law elements of the tort that we talked about last week. Second, look at what the court found wrong, lacking, with the common law as interpreted by the state of Alabama in the Sullivan case, and why the court found it necessary for the first time in history to impose First Amendment restrictions on a state's law of libel. And then third, look carefully at the court's holding, exactly what the court decided, what the rule is that comes out of the Sullivan decision. And then fourth, what alternatives the court might have used to achieve the same purpose of freeing the press and all of us from restrictions imposed by the law of libel. As I said when we started talking about libel, that law, that you might get sued for saying something that turns out to be false and is defamatory of someone, is a great inhibitor of what is said in public discourse, and in particular in the news media. And the greater the scope of the law of libel, the more frightened people who are speakers about public affairs are. Well, the Sullivan case began in 1960 with the publication of this full-page ad in the New York Times, March of 1960. And it was taken out by a group of extremely prominent supporters of the effort of Dr. Martin Luther King in the South. This is the fairly early stages of the civil rights movement, and the people who took out the ad were attempting to raise money, to call attention to what Dr. King was doing in the South, and to raise money to support the civil rights movement in the South. I don't know how well you see this, but you have it in the reader. The signers of the ad included people like Marlon Brando, Sidney Poitier, Jackie Robinson, Mrs. Eleanor Roosevelt, and a bunch of other prominent people. Heed their rising voices, the rising voices of the civil rights demonstrators in the South. They are seeking justice, and they need our help. The message of the ad. In the third paragraph of the ad, they're talking about Montgomery, Alabama in particular, where college students got together and demonstrated, singing "My Country 'Tis of Thee" on the state capitol steps. Their leaders, the ad said, were expelled from school, and truckloads of police armed with shotguns and tear gas ringed the Alabama State College campus. The dining hall was padlocked in an attempt to starve the students into submission. The ad then talks about the Southern violators of the Constitution, without naming names. In the 6th paragraph of the ad, it says the Southern violators have gone after Dr. King. They bombed his home, almost killing his wife and child. They've arrested him 7 times. Now they've charged him with perjury, a felony that could end up imprisoning him for 10 years. So there's a coupon to send in and a plea for donations in the ad. Nobody's named in the ad other than the supporters of it. But L.B. Sullivan, the police commissioner of the city of Montgomery, was shown the ad. And nobody knows exactly how it happened. I don't think he was a subscriber in Montgomery to the New York Times. It was a relative handful of copies of the Times were distributed in Alabama at the time. I don't know how he was shown the ad or how it was decided that he would sue the New York Times for libel, but he did. Brought a libel suit in the state court in Montgomery, seeking $500,000 in damages for having been defamed by this ad in the New York Times. $500,000 at the time was real money back in 1960. So you've seen the ad. What Sullivan claims was a defamatory of him. Let's see how it stacks up as a matter of common law. How well was Sullivan able to satisfy the common law elements of the tort? At this point in history, nobody was thinking First Amendment. Simply a state law, common law tort, whose elements we've discussed before. So how does his case stack up? Let's take them one by one. Any issue on whether the defamatory material was published? No? Yeah. Yeah, what was it? He wasn't named. Yeah, that's true that he wasn't named. Let's put that on hold till we reach of and concerning the plaintiff, which directly relates to that. Is there any issue with publication? That's because you have absorbed so completely the idea of republication. Because not a single word in this ad was written by the New York Times. The Times itself had no editorial product here. And yet they published the libelous material. What they did simply was republish what the sponsors of the ad had said. And the fact that the Times didn't write a single word of the ad has no effect on their liability. They are as liable for libel as the writers of the ad themselves. So he makes his case on whether something has been published. Then what about falsity? What's the situation with regard to falsity? Does he make his case or not? Robert? The ad, yeah. We'll call it the ad. Yeah, they didn't quite get it right. There were some facts that were inaccurate, put it that way. For example, the students, in fact, sang the Star-Spangled Banner in the demonstration rather than "My Country 'Tis of Thee." Some students were expelled not because of the demonstration, but because of a previous lunch counter sit-in. The dining hall was not padlocked to starve the students, or otherwise this didn't happen. The police didn't ring the campus. They were deployed nearby. Martin Luther King was arrested only 4 times, not 7. And the perjury indictment seems to have been done somewhere else. He was indicted for perjury, not convicted, but that seemed to happen somewhere else. So there were inaccuracies in the ad. It seems that those inaccuracies were fairly minor, inconsequential. And the thrust of the article about what the Southern violators did in brutally suppressing the civil rights demonstrations still stands independently of the inaccuracies. But the point in 1960, when Sullivan brought his suit about falsity, is that he didn't have to prove falsity, because truth was a defense under the common law, with the burden of proof, of proving the truth, on the New York Times, rather than the burden of proof of falsity being on Sullivan. And the Times couldn't be 100% successful on the truth because of the inaccuracies in the ad, inaccuracies that it had virtually no way of knowing. Then what about defamatory meaning? Does Sullivan make his case on defamatory meaning? Right? No doubt about that, really. I mean, if you grant that it's about him, we'll come to that in a minute. If it's about him, it's basically an accusation that this law enforcement official has been acting unconstitutionally, illegally, brutally, and violently suppressing peaceful civil rights demonstrations. That, in libel terms, injures him in his occupation and is considered libelous per se, libel on its face to defame somebody in their occupation. In the real world, you can question whether Sullivan was actually defamed by the statement about him in the community that he cared about, at least in segregationist Montgomery, Alabama at the time. His reputation was probably enhanced if he was known to be brutally suppressing civil rights demonstrations rather than ruined by this. But legally, it is correct that he was defamed in his occupation, injured in his occupation, by this accusation that he had been acting illegally and getting the police to violate everybody's rights. So somewhat of a paradox that he was not in fact injured by this, that he probably, it's like the Kim Kardashian thing we were talking about last time. He probably benefited in his community by this libel rather than was hurt. So, if they actually do it?
Yeah, like, I mean, some of the stuff in the article was correct, like, how much the doors and like, that you mentioned, like, he was doing all the other things. But I say all the information was accurate in the article. It was saying him with depression, but he did it, so they're just reporting on what happened, right?
Yeah, well, if they got it all right, then it's not libel because it's not false.
So would it be fake?
Sure, you can defame somebody, but you can't be successfully sued for defamation. I mean, that's the old law. That's the 18th century version of libel, which is defaming somebody is the wrong, whether it's true or not. But then, by the time of the Constitution or shortly thereafter, it was finally acknowledged that truth is a defense, so that if the defamatory accusation is true, the person who's defamed has no case, loses. Well, then what about of and concerning Sullivan? Tina? You know, it took a couple of logical steps, didn't it? I mean, here he is. He's not named at all. Is that fatal to his case? No. I mean, if they had said, for example, the chief of police of Montgomery, Alabama, did these awful things, readers can put 2 and 2 together. They know it was Sullivan. That's not an issue. But this is another step removed from that, because it doesn't say the chief of police did anything. It says the police did certain things and the Southern violators did certain things. So how does he get to bring his libel suit? Well, he brought in 6 witnesses, upstanding white citizens of Montgomery, Alabama, to testify before the all-white, all-male jury, that when they saw the ad, they were, of course, shown it by Sullivan's lawyers. They weren't subscribers to the Times either. When they saw the ad and read the ad, they made the connection between police, Southern violators, and Sullivan. And that they thought, this is, gee, Sullivan's being accused of these things. So they had actual witnesses who testified that they, as readers, made the connection to Sullivan. And then when the case went up on appeal, after the Times lost before the jury, the Times appealed to the Alabama Supreme Court. The Alabama Supreme Court added a rule of law that they announced in this case, to the effect that it's common knowledge, they said, that criticism directed at a government agency is considered by people who read it as criticism of the person in charge of the agency. So that when the ad talks about the police, that naturally, and in the minds of the average reader, according to the Alabama Supreme Court, relates to the head of the police department, Sullivan. So with that big assist from the Alabama Supreme Court, Sullivan is able to make his case that the ad is of and concerning him. That statements about a government agency can be considered to be about the official in charge. Well then, what about privilege? Does a privilege apply here? Fair comment? Fair comment protects statements of opinion, not fact. And what Sullivan is complaining about is not a matter of opinion, but false statements of fact about what the police and the Southern violators did. So the fair comment privilege wouldn't apply. What about the fair report privilege, the one that was used successfully by the National Enquirer in the Dorsey case, and that protects false statements that happen to be in reports, accurate reports of what goes on in courts or legislatures or other government proceedings? Well, none of these statements relates to a government proceeding at all. It's about events in the civil rights movement in Alabama, and not about lawsuits about that or criminal prosecutions about that. The ad doesn't purport to use a legal, I don't like to use legal language, but we'll use it there, you know what I mean. The ad doesn't purport to be a report of what went on in a court or in a legislature or anything like that. So the fair report privilege doesn't apply. And then what about fault? Right, this is common law. The common law rule being that libel was a no-fault tort and that a plaintiff could win a lawsuit for libel without proving any blameworthy state of mind. That is, that the New York Times meant to injure Sullivan or acted maliciously or even acted negligently. None of that was required to be proved. And Sullivan wins if he makes his case on those 5 elements without having to prove any intent to injure, negligence, anything like that. In fact, he did show, and probably it was for the purpose of justifying an award of punitive damages, he did show that some of the inaccuracies in the ad were inconsistent with some news reports that the Times itself had published, its own editorial product in the weeks before the ad came out. And Sullivan's lawyers argued, well, if the Times had only consulted its own files, recent files, it would have learned that some of these things were false and they should have done something about that. But nothing was really ever made of that because Sullivan didn't need to prove that the Times had acted with fault in order to win his case, and indeed the jury came back with a verdict of $500,000, exactly the sum that Sullivan had requested. You can say that Sullivan's case on the common law was a little thin, at least on a couple of the elements, like falsity and like whether it's of and concerning him, but under the common law at the time, and there was nothing unique about Alabama's rules on the common law of libel. At the time, that was a fair summary of what the situation was under the common law of libel, and Sullivan won his case. The Times had defended in part with a legal defense at trial that what they had done, published the ad, was protected by the First Amendment. But that was dismissed by the trial judge. But the issue was preserved, so that when the case went up on the Times appeal to the Alabama Supreme Court, the Times again argued, no matter what the common law is here, what we did is protected by the First Amendment to the United States Constitution, and you can't affirm a verdict that's inconsistent with the First Amendment. The Alabama Supreme Court dismissed that contention in a sentence, saying that the First Amendment has never been thought to interfere with a state's administration of its own libel law. And that was certainly true. Nobody had ever thought that the First Amendment prevented a state from enforcing its own libel law. And then the Alabama Supreme Court resoundingly affirmed the decision of the judge, the instructions that the judge had given the jury. Basically, the jury was instructed that all they had to find was whether the ad was of and concerning Sullivan and how much damages to award, because the judge instructed the jury that if it was of and concerning Sullivan, it was defamatory as a matter of law. It was libelous per se. Falsity was presumed, and there wasn't much left. It was published. There wasn't much left for the jury to decide, other than that it was about Sullivan. And as I said, the Alabama Supreme Court then affirmed that judgment, and on the other concerning point, added in the reasoning that criticism of government agency can be taken to be about the person who's in charge of that agency. So that ordinarily would have been the end of the story, the end of the road. The Times has taken the case to the highest court in the state of Alabama. Libel is purely a state law matter. Common law rules apply. You lost. That's the end. Pay up. But the Times had preserved its First Amendment contention, and so it decided to file a petition for certiorari in the United States Supreme Court and seek review there. The only issue that the Times could raise there is the constitutional one, whether the judgment of the Alabama Supreme Court was consistent with the First Amendment to the federal Constitution. The U.S. Supreme Court does not have jurisdiction over states' common law matters at all. And whatever the state says its common law is, stands. The highest court of the state makes the law on that, and the Supreme Court has nothing to say about it, unless what the state has done violates the federal Constitution, and that was the Times' contention when they took the case up to the Supreme Court, where we encounter a masterful opinion, one of the great Supreme Court opinions by a great Justice, William Brennan, who strings together history and philosophy and precedent and persuasive reasoning in this great opinion coming out holding that the First Amendment protected the Times after all. So let's look now at what, in general, the court found wrong with the Alabama common law that caused the Supreme Court to impose First Amendment limitations on how the states can protect their citizens' reputations. This is my interpretation of the court's opinion. I think that the court found that the test of truth as a condition for protecting speech was inconsistent with the First Amendment. That is,